Hello, my name is Anya Flynn and I'm Director of the Decision Support Service. In the following presentation, I will set out the key reforms introduced by the Assisted Decision Making Capacity Act 2015, including the guiding principles, the new decision support framework and the functions of the Decision Support Service. Right at the end of 2015, President Higgins signed an important reforming act, and that's called the Assisted Decision Making Capacity Act. So it is already law. Decision making capacity means being able to make your own decisions. And this act is all about how we support people as far as possible to make their decisions by themselves, and how we can help and protect them if they have problems with decision making. The Act is only for adults who are over 18, and the Act hasn't started working yet. So even though it was signed into law right at the end of 2015, it isn't something which is up and running yet. And why do we need a new law? Well, as you can see, the one that we use at the moment is really old. It's from 1871, 150 years ago. And under that old law from the time of Queen Victoria, we have the wards of court system. So right now, if the court decides that a person is of unsound mind and cannot manage their money or their personal welfare, then the court can make that person a ward of court. If you're a ward of court, the court makes decisions for you, and they could be big decisions about managing an inheritance or buying or selling property, really significant healthcare decisions, or they may just be small decisions. That's the effect of being a ward of court, that a small decision, such as one about applying for a passport, might no longer be your decision to freely take. After the new Act begins, there will be no new adult wards of court, and everyone who is a ward of court at the present time will come out of wardship within 3 years at the latest. And we understand there are about 2,150 adult wards of court at present. The Office of the Wards of Court and the Wardship Court will look after reviewing all of those cases. Under the new system, there is a new way of assessing if somebody has capacity to make a decision. And this is not a medical test. It's not about whether you have, for example, an intellectual disability or an acquired brain injury or an enduring mental illness or dementia. Instead, it's a functional test. So, you lack capacity is not a full sentence. The question is, do you have capacity to decide a particular thing at the time when you need to decide it? So thinking about that functional test, you have capacity if you can understand the information that you need to understand in order to make your decision. So perhaps it is that big decision about buying or selling a house, for example. You need to be able to retain the information about buying or selling the house for as long as you need to in order to make your decision. You need to be able to weigh up and use that information and communicate your decision. And this is important. You have to be supported if you need supports to communicate your decision. So you may be somebody who uses sign language, or speech and language therapy interventions may be required, or perhaps you need assistive technology, or just somebody who's really going to help explain it to you and help you communicate what you want to do in a way that suits you. Those sort of supports have to be made available, and the fact that you need those supports doesn't tell us that you don't have capacity. So intellectual disability, acquired brain injury, dementia, whatever, none of these things matters unless they actually affect your decision making. So it's an act which looks at ability, not disability. Let's look at the guiding principles which the Act introduces. So you have to start off by thinking that everyone can make their own decisions, and we call this the presumption of capacity, and that's happening already, or should be. So if you're an adult, you are presumed to be able to make your own decisions, unless it's the case that you can't, unless it is shown that you can't. People should be given all the support they need to help them make their own decisions. Wanting to do something that seems unwise doesn't mean that you don't have the capacity to decide to do it. Here are some more guiding principles. Intervene as little as possible. That means leave people to make their own decisions independently as far as possible. You have to respect their dignity, their privacy, their bodily integrity, and their autonomy or independence. Help people to make up their own minds as much as possible. Give people the supports before you even go looking at capacity. Ensure that you've done everything you can to support them in their decision making. Include the person at all times, even if formal supports have been put in place. Include the person in that decision making process and ensure that you respect will and preferences. So that's a person's own beliefs and values and what they want. That's your starting point, instead of the older idea of best interests. So it's not about what is good for somebody, it's about what they want as the starting point. And always act in good faith and for the person's benefit. What sort of decisions are covered by the new law? These could be personal welfare decisions like deciding where you live and who takes care of you. Health decisions like if you should have an operation. Property like if you need to buy or sell a house. Money like how you should spend or save your money, or decisions around applying for benefits. And there are 3 different categories of decision supporter under the Act. You have the lowest tier decision-making assistant, the co-decision maker in the middle, and then a decision-making representative as the top tier support. The lowest and the least formal of those steps on the ladder, the first tier of support, is the decision-making assistant. So this is when you choose someone whom you trust to help you understand information and the choices that you have. And the person that you choose to help you with this is called your decision-making assistant. Your decision-making assistant cannot be the owner or provider of residential services where you are living. So that if you are living in residential services, it can't be the person who owns or runs or works for that service. That's what the Act says about that. Your decision-making assistant will help you get the information you need and explain it to you if necessary. They will help you to let other people know about your decision, and they will help you to have your decision carried out. But you're still making the final decision yourself. The middle tier then is the co-decision maker. So this happens when, if you need somebody to share making decisions with you, you can choose somebody who becomes your co-decision maker. Again, that should be somebody who is a close friend or a family member, somebody whom you know and trust. And then you can make a co-decision making agreement that sets out the kind of decisions that you want to make together with your co-decision maker. Again, your co-decision maker can't be the owner or provider of your residential service if that's where you live. They will help you get the information you need and will explain it to you if necessary. They won't stand in your way unless there is a risk of serious harm from what you want to do. And there will be new rules for this co-decision maker to follow. So when you're working with a co-decision maker, specific decisions are shared by both of you. And finally, at the top tier then, we have the decision-making representative. The decision-making representative is a person who is appointed by the court who then makes certain decisions on your behalf. The court will always consider whom you want as your decision-making representative. Your decision-making representative still has to consider your will and preferences, and that means that they must try to make the decision that you would want. The Act also provides for planning ahead, which is something that all of us should consider doing. The first way that you can plan ahead is with an enduring power of attorney. So you can appoint a person now who will act on your behalf at a point in the future if you're not able to do so for yourself. You decide what sort of decisions your attorney will make in the future, and these could be decisions about, for example, where you live or how your money is going to be handled. And the other way of planning ahead is with an advance healthcare directive. That's a legal document, and you can use it to let people know your wishes about medical treatment. You can choose a person to make decisions in the future about medical treatment if you become unable to make those decisions yourself. Let me tell you about the Decision Support Service. This is the new service which is set up under the Act to manage all of these new supports that we've been talking about, and it will be opening fully for business when the Act is commenced. I am the director of the Decision Support Service, and I have a number of jobs to do. So the director has to let everyone know about supported decision making, tell people how to use these decision supports or how to be a decision supporter, and then we will be supervising these decision supporters to make sure that the person who is supposed to be supported is getting all the proper help. And we will investigate complaints about decision supporters if that doesn't seem to be happening properly. We will always, in the Decision Support Service, be able to make reports and recommendations about how things can be better. This is a new act and we want it to work really well. So we'll be happy to get feedback about how things could be done better, and we can make recommendations for changes. And what will keep you safe if you're a person who has one of these arrangements? Well, it is an offence to make a person enter into a supported decision-making arrangement against their will. It's an offence to put any false information in any of those documents. It is an offence for a decision supporter to ill-treat or neglect the person they're supposed to be taking care of under the decision support arrangement. And there are criminal penalties if all of that is going really badly wrong. I should say that in the Decision Support Service, what we want to do is help decision supporters to do the best job that they can. What can you be doing to get ready in the months leading up to commencement of the Act? These are some of the questions that you might be thinking about. Will I need the new supports under the Act? At present, how are decisions being taken? Are decisions being taken by another person on my behalf? And can I make these decisions for myself? Who can help me to make my own decisions as far as possible? When the new Act begins, will I require one of those new formal arrangements? And that will really depend on what decisions are happening for you. Who can be my supporter in one of these formal arrangements if I need one? Am I able to plan ahead? Can I have an enduring power of attorney? Can I make an advance healthcare directive? Or if I'm one of those people who is a ward of court at present, how can I be supported with that review process which the Wardship Court is going to carry out within 3 years of commencement of the Act? And where do I go to find out more? Well, you can come to the Decision Support Service and I'll say a little more about that. We need to make sure that we are doing what it says in the United Nations Convention on the Rights of Persons with Disabilities. So that's a really important international convention which Ireland has to follow. And that convention says that full human rights for all persons with disabilities must be guaranteed without discrimination. It speaks about the right to recognition everywhere as persons before the law, so that persons with disabilities have legal capacity on an equal basis with everyone else. That means that they have the entitlement to hold and to exercise rights, because loss of your decision-making capacity is not an off switch for your human rights. Thank you for viewing this presentation. You will find more information elsewhere on our website, including frequently asked questions and guidance on what you can do to prepare for commencement. Thank you.